And earlier, before the reinstatement, a federal high court in Kano has issued an order preventing Governor Abba Kabir Yusuf from reinstating Emir Muhammadu Sanusi II until a suit challenging the reinstatement is resolved. The order also opposes the dissolving of Bichi, Gaya, Karaye and Rano emirates. Justice A.M. Liman directed all parties to maintain the status quo until the case filed by Sarkin, Dawaki, Babba and Aminu Babba-Dan'Agundi is decided. The court allowed serving documents on the Inspector General of Police in Abuja. The defendants include the Kano State Government and various state and security officials. The next hearing is scheduled for June the 3rd. And joining me now via Zoom to discuss this is a legal practitioner, Abba Hikma Esquire. Good evening and thank you for joining me on the News Hour. Well, some would describe this as basically a scene from a movie if this wasn't happening before our eyes. But then again, walk me through your thoughts when you first, heard that they had proceeded. The Kano State Government, of course, had proceeded with the coronation of and the handing of the staff of office to Sanusi II, of course.
Thank you very much for having me on this program. And my initial thoughts, like you asked, depend on so many factors, about two factors. And that is that if Kano State Government has been validly and accurately staffed by the order of court restraining it from proceeding in that respect, then the law is that every action done subsequent to service of court order is null and void, and the courts are always in the habit, and always inclined to nullifying any action done in violation of order of court. But if at the time the governor of Kano State proceeded to hand over the appointment letter to the emir, the newly appointed emir and the staff of office, if as at that time, the government, maybe through the Attorney General or any other government, any party of the Kano State Government before the court, if as at that time they have not been served by order of court, then you could not assume they are aware of the pendency of the matter, because in law, the pendency of a matter or the pendency or subsistence of an order of court can only be assumed when the party against whom the order is issued has been validly served and he has made endorsement. So it is two ways. If the government is served, you can say it's null and void. And if the government is not served, as at when the governor was proceeding, then you could say that it has been validly done. And then, the order given is an order restraining the government from doing something which has been made already. You understand what I mean? Part of my concern when I saw the order was that if there's an order of court restraining the government from doing something which has been done. Logically speaking, you cannot stop me, for example, from participating in this program after I have participated. So the law does not stop a concluded act. But, this is just one point of looking at it. But really, there are other bottlenecks, there are other very serious legal concerns and issues that does not have to do with the order of court,
okay,
which has to do with the appointment itself. I don't know whether you have time.
Another issue here, and that is on the question of whether the order by the court stands in the first instance, because there's also developments that the governor of Kano State had mentioned that the judge that delivered judgment on that very case was actually not in the country. So I don't know if you could walk us through the possibility of the judge being able to enforce judgment, or rather give judgment when he's out of the court and even out of the country.
I know in the Federal High Court, there's a 2020 COVID-19 practice direction, which allow courts to sit remotely and conduct their proceedings electronically. Although that court practice direction was issued during the COVID-19, that particular set of legislation or rule of court has continued to apply in proceedings before the Federal High Court, even as recently as this year. So there is a law, there's a rule of court that allows courts to sit remotely. A judge does not have to be around. He can just stay from wherever he is. I'm sure Nigerians are not new to this. Now, if that is what happened, you can say there's no problem, there's no cause. But if that is not what happened, a judge merely sits, away from where he should be, away from the courtroom, and then misrepresent facts and show that he's in court and that a certain lawyer appeared before him, or that he has perused the physical copies of the processes filed before him, then that is anything not less. That is, a very serious professional misconduct, which the judge can be punished seriously at the very before.
Okay. Now, in this instance, what would you then say would be the next steps now in the instance that, for example, the Kano State Government had flouted court order? So what's the next step for the Kano State High Court that gave the order in the first place, and also for those who had approached the court in the first instance?
Like I told you before, if there is any flouting of an order of court, any action done in violation of an order of court is null and void in the eyes of the law. And it doesn't have to be this court. Assuming this case before the Federal High Court does not even succeed, eventually, no court in Nigeria will validate or ratify whatever has been done in violation of the order of court, even assuming, the case does not succeed. As we stand, there's an order of court which restrains Kano State Government from doing anything. And if Kano State Government has been served by that order, then Kano State Government has a duty in law. There is no discretion here. They have a duty in law to restrict themselves and to refrain from doing anything which the court order prohibits them from doing, and any such action will be seen by the court and the law as a nullity entirely.
All right, Barrister Abba Hikma, legal practitioner, thank you so much for providing perspectives on this issue, which, of course, definitely will make it to the history books. It's been a lovely conversation.
Thank you very much. Thank you.